You are listening to HOA Neighbor Court. This is how a warning turned into a threat. The post cap cracked in half in my hand, and Sharon yelled that damage meant non-compliance, and she would fine me for that too. "You are making my case for me," I said, and I held up the two pieces so my contractor could see the split. Sharon White stepped closer, her reflective safety vest catching the last orange glow from the streetlight, and she jabbed her finger at the broken cap like it was evidence of arson. "That is destruction of HOA-approved materials," she said. "I am documenting this for the hearing." She pulled out her phone and started snapping photos while my contractor, a guy named Luis, who had been doing fences in Salt Lake City for 15 years, stood at the curb with his truck idling and his trailer full of cedar posts. He looked at me, then at Sharon, then back at me, and he said, "Man, I do not need this kind of trouble." I told him to hold on, that I had every permit and every approval in writing. But Sharon cut me off. "Those approvals are under review," she said, "and until the Riverbend Fence Compliance Association clears the setback question, no work starts." I felt my chest tighten because I drive rideshare, and my car was parked in the driveway behind Luis, and if this dragged on, I would miss my evening shift. I am supporting family back home, and I cannot afford surprise fees or a tow bill, so every hour of this nonsense was money I did not have. Sharon had been the neighborhood watch liaison for Riverbend Fence Compliance Association for 3 years, and she treated every resident like a suspect. The HOA name was on every street sign and every newsletter, always in bold, always reminding you that covenants were sacred. I moved here 6 months ago because the rent was cheaper than downtown, and I could park my car without permit drama, or so I thought. The fence I wanted to build was a simple 6-foot cedar privacy fence along the back property line, replacing a sagging chain link that the previous owner left. I filed my application in March, paid the review fee, got a written approval letter in April, and scheduled Luis for late May. Everything was clean until Sharon decided the survey I submitted was incomplete and demanded I hire a new surveyor to confirm the setback. I told her the survey was done by a licensed professional and matched the plat on file with the county, but she said the HOA guideline required a second opinion for fences near easements. When I asked for a copy of that guideline, she told me it was part of the internal enforcement manual and not available to homeowners unless I filed a formal records request. That was 2 weeks ago, and I still had not received anything. Luis leaned against his truck and pulled out his phone. "Look," he said, "I got 2 more jobs today. If she is going to shut this down, I need to know now." Sharon turned to him and smiled, the kind of smile that makes you check your wallet. "You are welcome to leave," she said. "This property is under compliance review, and any work performed during review is considered unauthorized construction." She pulled a rolled-up survey map from her clipboard, the same prop she dragged to every HOA meeting, and tapped it against her palm like a gavel. Luis looked at me and said, "Man, I have seen this before. She is going to call the county, claim you are violating setback, and then I am the one who gets the stop work notice. I cannot afford that." I felt my stomach drop because I knew he was right. Sharon had already sent me 4 certified letters in the past month, flooding my mailbox with notices about fence height restrictions, color approval requirements, post hole depth standards, and a brand new easement interpretation that somehow applied only to my lot. I kept every letter in a tabbed evidence binder because I knew this was targeted, and I had screenshots of the HOA group chat where Sharon and 2 board members coordinated the enforcement wave. She said I could fine you daily until you give up and you cry, and someone responded with a laughing emoji. I told Luis I would pay him a cancellation fee and reschedule once I cleared this up. He shook his head and said, "Good luck, man," and he pulled his truck out of the driveway. Sharon watched him go, arms crossed, the reflective vest glowing under the porch lights that were starting to turn on across the street. The couple on the porch 2 houses down had stopped watering their plants and were just standing there watching like it was a show. Sharon turned back to me and said, "You signed the covenants. Now you live the covenants." That was her catchphrase, and she said it every time she handed out a violation notice. I asked her what specific rule I was violating, and she pointed at the fence line. "Your string line is 6 inches into the easement," she said. that is non-compliance with Section 4.7.2. I asked her to show me Section 4.7.2, and she said it was in the amendment packet from 2019 that was mailed to all residents. I told her I moved in 6 months ago and never received any amendment packet. She smiled again and said, "Ignorance is not an exemption." I went inside and pulled out my binder. I had the original approval letter, the survey, the contractor quote, the HOA bylaws I downloaded from the county website, and the group chat screenshots. I also had a friend, Marcus, who was a CPA and spotted red flags in HOA ledgers for fun. I called him and said I needed help, and he told me to send him every financial document the HOA ever gave me. I did not have much, just the quarterly due statements, but he said that was enough to start. He also told me to file a formal records request for the meeting minutes, the enforcement manual, and the bank statements, because if Sharon was running a selective enforcement campaign, there would be a paper trail. I drafted the request that night and sent it certified mail the next morning. 2 days later, I got a response from the HOA management company saying my request was denied because I had an active compliance dispute, and records access was suspended until the matter was resolved. That was when I knew this was going to get ugly. Sharon was not just enforcing rules, she was blocking my ability to fight back. I called the management company and asked how I could resolve a dispute if I could not see the rules, and the woman on the phone said I needed to attend the next board meeting and present my case. The meeting was scheduled for June 10th, which gave me 2 weeks. I marked the date and kept working my rideshare shifts, but every time I came home there was another certified letter. One claimed I missed a hearing I was never told about, which automatically triggered a $100 fine. Another said the HOA was escalating the matter to legal review, and I would be responsible for attorney fees. I took pictures of every envelope, every postmark, every notice, and added them to the binder. Marcus called me back and said the due statements showed irregular late fees tied to enforcement actions, and he wanted to see the full ledger. I told him I could not get it, and he said, "Then we make them show it at the meeting." The week before the meeting, Sharon escalated again. I came home from a late shift and found a tow truck idling in front of my house with Sharon standing beside it, directing the driver like an air traffic controller. She pointed at my car and said, "That vehicle is parked in violation of overnight guest restrictions." I told her I lived here and the car was registered to my address. She said guest parking was limited to 72 hours, and my car had been in the same spot for 4 days. I told her that was insane, that I drove it every day for work, and she pulled out her phone to show me time-stamped photos of my car in the driveway at various times. The photos were real, but the claim was absurd. The tow driver looked uncomfortable and asked if I had proof of residency. I showed him my driver's license and my mortgage statement, and he said he was not towing a resident vehicle without a court order. Sharon's face went red and she said, "You are obstructing HOA enforcement, and I will add this to the hearing record." The tow driver got back in his truck and left. The couple on the porch was still watching, and this time the guy gave me a thumbs up. That night I went through the group chat screenshots again and found the smoking gun. Sharon had posted a message 3 weeks earlier saying, "We need to make an example out of someone, so the rest fall in line." Another board member replied, "The new guy on Aspen is perfect. He does not know the ropes yet." Sharon responded, "I will handle it. I have the easement angle ready." I screenshotted the thread and printed 3 copies. One for me, one for Marcus, and one for the officer on scene if things got physical. I also noticed something strange in one of Sharon's photos. She had taken a picture of my fence line with a tape measure stretched along the ground, claiming my string was 6 inches into the easement. But in the reflection on her phone screen, you could see her holding the tape at an angle to fake the result. I zoomed in, printed the image, and added it to the binder with a sticky note that said Exhibit C. The board meeting was held in the community center, a beige stucco building with a metal roof and a parking lot full of pickup trucks. I got there early with Marcus and my binder. Sharon was already inside, setting up a projector and arranging her rolled-up survey map on the table like it was a courtroom exhibit. The board president, a retired engineer named Ed, sat at the head of the table and looked bored. 2 other board members flanked him, both middle-aged men in polo shirts. I signed in and took a seat in the front row. Marcus sat beside me and whispered, "Let her talk first. Do not interrupt. Let her hang herself." The meeting started with standard business, budget updates, landscaping bids, pool maintenance. 20 minutes in, Ed called my name and said, "We have a compliance matter regarding fence construction at 487 Aspen Lane." Sharon stood up and launched into her presentation. She claimed I had ignored multiple notices, missed a mandatory pre-construction hearing, violated setback requirements, and refused to cooperate with the compliance review process. She showed slides with photos of my property, my string line, my car in the driveway, and a diagram of the alleged easement encroachment. She talked for 15 minutes, and every sentence was designed to make me look like a reckless rule breaker. When she finished, Ed asked if I wanted to respond. I stood up, opened my binder, and said almost nothing, because silence makes people talk. I set the binder on the table, flipped to the first tab, and waited. Sharon said, "Well, are you going to defend yourself, or just sit there?" I said, "I am going to let the evidence speak." I pulled out the approval letter and slid it across the table to Ed. I pulled out the survey and slid it next to the letter. I pulled out the group chat screenshots and the timestamp notice log. Marcus leaned over and said, "And we are requesting a full financial audit of enforcement-related fees collected over the past 2 years." One of the board members, a guy named Tom, shifted in his seat and said, "Why would we need that?" Marcus said, "Because the due statements show irregular late fees tied to enforcement actions, and we believe there is a pattern of selective targeting." Sharon stood up and said, "That is a baseless accusation." I said, "Is it? Because the chat logs show you coordinating enforcement actions with board members before any violation was reported." I flipped to the next tab and read the message out loud. "We need to make an example out of someone so the rest fall in line." Ed's face changed, and he asked to see the screenshots. I handed them over. Tom looked at Sharon and said, "Did you write this?" Sharon said, "That was taken out of context." Marcus said, "Then provide the full context. Request the meeting minutes from the April board session and the enforcement manual you keep referencing." Ed said, "We can do that." Sharon said, "Those are internal documents, and I object to releasing them without proper procedure." Ed said, "Overruled. This is a compliance hearing, and if the homeowner is requesting records, we provide them." The mood in the room shifted. The other board members started whispering, and Sharon realized she was losing control. She tried to pivot back to the easement issue, but I pulled out the photo with the angled tape measure and the reflection. I said, "This is Exhibit C. You claimed my fence line was 6 inches into the easement, but your own photo shows you holding the tape at an angle to fake the measurement." I passed the printout to Ed. He studied it for a long moment, then looked at Sharon and said, "Is this accurate?" Sharon said, "I was adjusting for slope." I said, "The property is flat." Ed said, "We will table this matter pending an independent survey." Sharon said, "That is unnecessary, and I am prepared to issue a final violation notice tonight." Ed said, "No, you are not. The board is suspending enforcement action until we complete a review." Sharon's mouth opened, but no sound came out. Tom said, "I move to suspend." The third board member said, "Second." Ed said, "Motion carries." Sharon grabbed her rolled-up survey map and walked out. The meeting ended 10 minutes later, and Marcus and I walked out into the parking lot. He said, "That was beautiful." I said, "It is not over." He said, "No. But you just bought yourself time." I went home and checked my mailbox. Another certified letter. This one claimed the HOA was placing a lien on my property for unpaid fines related to the missed hearing. I photographed the envelope, opened it, and read the notice. The fine amount was listed as $800, with a note saying it would increase by $50 per day until resolved. I called Marcus and he said, "That is retaliation, and it is probably illegal." file a complaint with the state HOA ombudsman, and request an emergency hearing. I did both that night. The ombudsman office responded 2 days later and scheduled a hearing for June 25th. The letter said the HOA was required to provide all enforcement records, meeting minutes, and financial documents related to my case by June 20th. Sharon did not respond to the request. The management company sent a terse email saying they were compiling the documents. 2 weeks passed and I got a call from the mortgage company. They said my refinance inspection was scheduled for July 1st, and any active dispute note on the property title could derail the process. I told them I was fighting an HOA lien, and they said, "You need to resolve that before we can proceed." I felt the time pressure closing in because I was counting on the refinance to lower my monthly payment and free up cash for the family support I sent home every month. If this dragged into August, I would miss the rate lock and lose thousands over the life of the loan. I called Marcus and said, "I need to end this now." He said, "Then we go nuclear at the hearing. Bring everything. And I mean everything." The hearing was held in a county courthouse annex, a gray concrete building with metal detectors and laminated floor signs. I showed up with Marcus, my binder, and a USB drive with all the digital evidence. Sharon was already there with Ed and Tom, plus a lawyer the HOA had hired, a guy in a gray suit who looked like he billed by the minute. The hearing officer was a retired judge named Callahan, who had seen 1,000 HOA disputes and looked like he was done with all of them. He called the session to order and asked the HOA to present their case. The lawyer stood up and said my failure to comply with notice procedures and setback requirements justified the fines and the lien. He spent 20 minutes walking through a timeline of notices, deadlines, and missed hearings. When he finished, Callahan asked if I wanted to respond. I said, "Yes, Your Honor, and I need 5 minutes." He said, "You have 10. I opened the binder and walked Callahan through the approval letter, the survey, the group chat screenshots, the angled tape measure photo, the fake missed hearing notice, the tow attempt, and the retaliation timeline. I showed him the dues statements with the irregular late fees and Marcus's analysis of the enforcement pattern. I played audio from my phone of the tow driver conversation where Sharon tried to impound my car. I handed over the USB drive and said, "This contains timestamped records of every interaction, every notice, and every group chat message related to this case." Callahan looked at the HOA lawyer and said, "Do you have meeting minutes that authorize these enforcement actions?" The lawyer said, "We are still compiling those." Callahan said, "That is not an answer. Do you have an enforcement manual that defines the setback rule she cited?" The lawyer said, "The manual is internal." Callahan said, "Then how is a homeowner supposed to comply with a rule they cannot access?" The lawyer did not answer. Callahan flipped through my binder and stopped at the group chat screenshots. He read the message out loud. "We need to make an example out of someone, so the rest fall in line." He looked at Sharon and said, "Did you write this?" Sharon said, "That was a private communication." Callahan said, "It is evidence of intent, and it goes directly to the question of selective enforcement." He turned to the HOA lawyer and said, "Does your client have insurance coverage for harassment claims?" The lawyer said, "I would need to check." I reached into my bag and pulled out the trump card. It was a copy of the HOA insurance policy I had requested through a public records request to the management company, and it included a rider that specifically excluded coverage for punitive damages related to harassment, discrimination, or retaliation. I slid it across the table and said, "They do not. The policy excludes harassment claims, and if this goes to civil court, the board members are personally liable." Callahan read the document, looked at Ed and Tom, and said, "Are you aware of this?" Ed said, "No, we were not." Tom said, "Sharon told us the insurance covered everything." Callahan said, "This hearing is adjourned pending an independent review of the HOA enforcement procedures and financial records. The lien is suspended, all fines are suspended, and the homeowner is authorized to proceed with his fence construction under the original approval." If the HOA wishes to challenge that approval, they must file a formal complaint with supporting documentation within 30 days. Sharon stood up and said, "I object. This is procedural misconduct." Callahan said, "Your objection is noted and overruled." The HOA lawyer said, "We will file an appeal." Callahan said, "You are welcome to try." The session ended and I walked out into the courthouse hallway with Marcus. He said, "You just saved yourself $800 and probably another $2,000 in legal fees." I said, "I want more than that. I want the whole system fixed." If you are enjoying this story, hit that like button and subscribe for more HOA drama and satisfying payback. The next week, the State Ombudsman Office opened a formal investigation into Riverbend Fence Compliance Association, based on my complaint and the evidence I provided. They requested a full audit of enforcement-related fees collected over the past 2 years, meeting minutes, and all communications between board members and the management company. The management company cooperated immediately, probably because they realized they could be held liable if they obstructed. The audit results came back in early August, and they were devastating. The auditor found that Sharon had issued over 60 violation notices in the past 18 months, and 42 of them were tied to properties owned by people who had filed complaints or questioned board decisions. The fines collected from those notices totaled $18,000, and almost none of them had been properly documented in the meeting minutes. The auditor also found that Sharon had created a separate enforcement fund that was not reported in the quarterly financial statements, and she had used that fund to pay for private survey work and legal consultations without board approval. Ed called an emergency board meeting and invited me to attend. I showed up with Marcus and found the room packed with residents who had been on the receiving end of Sharon's enforcement campaign. A woman named Claire stood up and said Sharon had fined her $300 for painting her front door without approval, even though the covenants only required approval for exterior structure changes. A guy named Paul said Sharon had tried to force him to remove a garden shed that was fully compliant with the setback rules, and when he refused, she filed a lien on his property. One after another, people shared stories of targeted enforcement, fake deadlines, and harassment. Sharon was not present. Ed said she had resigned from the board effective immediately, and the HOA was suspending all enforcement actions pending a complete policy review. The board voted to refund all fines collected under Sharon's enforcement campaign, which totaled over $12,000 once they included the penalty interest and late fees. My $800 lien was canceled, and I received a formal apology letter from Ed. The letter also included a policy clarification that destroyed Sharon's favorite tactic. The new policy stated that any enforcement action had to be based on a publicly available rule, with written notice provided at least 30 days before any fine or lien, and homeowners had the right to request an independent review before any penalty took effect. The policy also required the board to publish meeting minutes within 10 days and make all enforcement records available upon request. It was exactly the kind of transparency Sharon had spent 3 years avoiding. I finished my fence in early September. Luis came back and completed the job in 2 days, and the cedar posts looked perfect along the property line. The couple on the porch stopped by to say congratulations, and the guy said, "I wish I had kept records like you did." I told him he should, because HOAs do not fix themselves unless you force them. Marcus helped me file a small claim suit against Sharon personally for the retaliation and harassment, and we settled out of court for $2,000. She also agreed to a consent order that banned her from serving on any HOA board in the state for 5 years. The HOA insurance company reviewed the case and decided to non-renew the association's policy unless they implemented the new transparency measures and hired an independent management company to oversee enforcement. Ed and Tom voted to hire a new company, and the residents approved the change at the annual meeting. The fallout did not stop there. Sharon had posted a long rant in the neighborhood Facebook group claiming the audit was politically motivated and I had fabricated evidence to smear her reputation. The post got reported within an hour, and the group admin removed it and replaced it with a correction. The correction included a link to the public audit report and a statement that Sharon's claims had been investigated and found to be false. Several residents commented with their own stories, and the thread turned into a support group for people who had been targeted by selective enforcement. The HOA board issued a formal apology to the neighborhood and committed to implementing the new policies immediately. By October, the complaints had piled up so high that the county HOA ombudsman used Riverbend as a case study in a training seminar for other associations, and the story made it into the local news as an example of what happens when boards ignore transparency requirements. I kept my rideshare schedule and hit my refinance deadline in early November. The new rate saved me $200 a month, which made a huge difference when I sent money home. My family had no idea how close things had come to falling apart, and I wanted to keep it that way. The binder stayed on my desk as a reminder that sometimes the only way to win against a system is to become better at the system than the people running it. Marcus framed one of the group chat screenshots and gave it to me as a joke. It still hangs in my kitchen. The neighborhood settled into a new normal. The enforcement policy was published online, meeting minutes were posted within a week, and residents actually started attending board meetings because they trusted the process again. Sharon moved out of the neighborhood in December, and I never saw her again. The rolled-up survey map was left behind in the community center, and someone turned it into a running joke. At the holiday potluck, Ed brought it out and used it as a makeshift pointer during his speech about transparency and accountability. Everyone laughed, and someone asked for her motion on record. The whole room lost it. I still drive rideshare, and sometimes passengers ask me about the neighborhood. I tell them it is quiet now, and they usually say that is boring. I tell them boring is underrated when the alternative is getting fined for existing. They laugh, but I am serious. The fence is still standing, the car is still in the driveway, and the binder is still on the desk. That is all I need. Thanks for watching, and I hope you have a great day.